So I'll just refer here to everyone in the room with a very warm, even though slightly colder than usual, good morning to everyone, also online. It's very nice to have moments of gathering. We are in the middle of the semester at Nova School of Law, many activities, classes. We are a School of Law that is very active on different fronts, and it's nice that every one of us just took sometimes, or if you can stay with us the entire morning, just together and focus on having an enriching discussion all together on a topic that is very timely, but is also a topic that we have been discussing all together with the students and with our partners in Lisbon on different occasions. So I will take a few minutes of your time after the opening remarks, so I just pass the floor to my dear colleague Francisco Pereira Coutinho, who's associate professor here at Nova School of Law, and by the way, he really embodies a little bit the hybrid nature of the faculty members of our university, in the sense that we are here teaching the law and we are inviting always students to join academic discussions, but we are also trying to coordinate research efforts on different fronts. So Professor Francisco is also coordinator of several of our research centers at the Nova School of Law, and has been collaborating also with Nova IPSI, and specifically with the collaboration we have with the Consumer Empowerment Project on the data protection research. So I'm particularly pleased to have him here, because it's really a joint venture of academic research between professors and students, and he has been doing that at Nova School of Law for more years than me. So thanks again for joining us, and Francisco, I'll leave you the opening.
Thank you very much, Giulia. Good morning, everybody. It's really a pleasure to be here and in order to actually open this very challenging conference. As Giulia said, I'm a professor here at Nova. I was an alumni. I started the program in 1997, and of course I'm also a proud member of IPSI, and congratulations to Giulia for organizing another international conference within her Knowledge Center, who has been a huge success, although it only has around 2 years, right? So, which is an amazing, outstanding work, and she's the example of actually integrating several fields and actually integrating students into the academic research. But I was saying that I am an alumni of Nova, of this school since 1997, and I want to say that because yesterday, as Giulia said, we had the graduation of the students. We threw a big event where they got their diplomas, and one of the moments of that event was, and I would like to go back to that, an evocation of Professor Carlos Ferreira de Almeida. And I will mention him because of Marco and the Consumer Empowerment Project. I don't know if you know Marco, but Ferreira de Almeida was one of the two founding fathers of our university. I'm a public lawyer. The other founding father is more well known, is Diogo Freitas do Amaral. He was a famous politician here in Portugal, also a constitutional law professor. But Carlos Ferreira de Almeida was also actually the soul behind the project. And he's really interesting for you and for this event and for the SAP project, because he was the one bringing the consumer law studies into Portugal. So I was an alumni. I did the graduation here, and this was the first school to have a consumer law course within the graduation. And that was, back then, something that other schools didn't even thought it would be possible. And of course, he left a mark. One of our vice deans, Jorge Carvalho, did, I think, the first PhD in consumer law, and we started to do research and empirical work on consumer law rights here in Portugal already in the beginning of the century. Of course, this is Giulia's Knowledge Center is more focused on IP. Of course, it has a lot of connections also to the project, the Consumer Empowerment Project. But this is, I think, an amazing story to tell. And of course, the fact that you keep coming here several times within several of our research events is just a testimony to the work that Professor Carlos Ferreira de Almeida actually started, because this is the most interesting thing in academia, which is you can do your work, but actually what you leave in the people that you train and the ideas that you actually project is the things that actually build the foundations of a school. And this is still a very recent school. Again, we only have about 30 years, but still we have a lot of stories to tell. And thank you, Marco, for actually helping us internationalize this project that we started in consumer law and basically allowing us to take it further. So thank you, Giulia, for organizing this conference on the topic that I really don't know nothing about. So I will stop here because I have nothing else to say, unless reaching you all and hoping you have a great experience today.
Thank you so much. Thank you so much, Francisco. It's true that addressing always the institutional greetings is something that is nice, because ultimately you are in an institution that welcomes you to join us and think. So the welcome of Nova School of Law had to be done also by someone who has really grown academically inside the institution, and I value Francisco's presence a lot today. According to the program, I'm now due to pass the floor to Marco, but actually I begged his patience because I wanted to address my personal thank you to many people, and I will not take too long. And then I thought, before Marco, who is here to represent and to talk about the collaborations we've been now carrying out for the last year, and also talking about copyright law, because I couldn't stop him from talking already and jumping into the topic, I wanted to have a few moments just to set the scene for everyone. We have in front of us an audience that is mixed. I see familiar faces, I see new faces, I see practitioners and students. I know that online we have a diversity of participants. So I really wanted to make sure we all start on the same ground. And as I said, I will take just the first minute to do something that even yesterday at the graduation day and our Dia da Faculdade, I felt it is so important to stop and do, because the thank you notes is something just to tick a box and say, oh, I have to thank, right? Like my dean and the institution and our administrative staff. But that's something that at Nova we take proper time sometimes to do, and we celebrate immense amount of work that a lot of people put together. So without getting too emotional, the first thank you is to our speakers, because they considered it worth it to travel all the way to Lisbon, or not to travel, because Rossana Ducato is also with us online due to schedule. She could not, but she would have joined also online. So in any case, consider it worth it to stop what you're doing, and taking the time to prepare and join a discussion is something we don't take for granted. So I will introduce you one by one during the event, but this is a general thank you for joining us today. A big thank you also to the Nova School of Law communities, to the students who have been really passionate about topics related to intellectual property and sustainability over these last 4 years. Usually when we have our annual lecture, I get more emotional and I say they are the reason why I started the center. But actually today's conference, after a lot of discussions we had with Marco about organizing more events and opening the doors of universities together, they were also the one convincing me to do this event, because the discussions in the classrooms were really very, very lively. A big and by no means less deep and serious thank you to the whole project. So Marco and Luca are here representing the Consumer Empowerment Project and Euroconsumers. This is a thank you that is not just institutional, but is a thank you that I personally ask you to bring on to your teams, because I do think it's not easy to run a project of this caliber, working with so many institutions, and we are extremely happy that we are part of this network. A thank you to Nova IPSI, because I can tell you many things. We will have also some booklets that is the big achievement of last year's activities that you are more than free to pick up and bring home, but I can really share with you that Nova IPSI is just a hub of energy, and keeping up with academic research is something that is not just difficult because it tends to be very solitary as an activity, but it's something that really requires a lot of people challenging you and supporting you. And Nova IPSI has been this for the last years, and this is incredible. Specifically in Nova IPSI, a big thanks to my collaborators Amanda and Alini, who literally put together this event. So during the lunch break, don't come and thank me for anything that is happening today, because they took care of the whole logistics. A big thanks also to our administrative staff members, specifically Cristina and Diogo, who took care of all the logistics together with Amanda and Alini. And I'm here, for those of you who don't know me, serving as the intellectual property law professor at Nova School of Law. That's a huge honor, and that's also a lot of work, because I come from a research field that is mostly copyright, but then during the years I'm exploring and expanding, not only teaching other IP fields. And I do value the fact that I'm supported by faculty members and researchers in this school and in this law faculty that really share with me the passion of bringing the scholarship and bringing the academic debate a little bit further. So these were the thank you note, and please, I really hope they didn't sound boring, because they were. Now, setting the scene before passing the floor to Marco could mean giving a keynote speech, but this is something I don't want to do. So when we designed the event, I didn't want myself as a keynote speaker. I didn't want any keynote speaker. I wanted just a round table that is not round, but we created. And I think that inviting people to share perspectives is always better, rather than imposing a dominant perspective and then discussing that. So the idea behind this event was really, if I talk, I just share my 2 cents, and that's gonna be it. So why we thought maybe I can set the scene is just to have a short little contribution that is definitely a personal view in light of my own research, that aims just at equipping everyone in the room with some basic information. So it's not a long inspirational speech that I'm giving about the topic of today's discussion, that is navigating the use of copyrighted and non-copyrighted content for AI training, something that some students of mine felt it was very technical, but then they debunked the myth by themselves and found very interesting. But instead of a long inspirational speech, I will just give you short pieces of information that I think help following the debates that will be after this. And it's going to be short and informative, but for those of you knowing me, this is no surprise. It is also a special kind of onboarding, because I will not present to you what has been written until now about AI and IP, and then AI and copyright, and then specifically copyright and AI training. I'm not onboarding you in a classical way. I'm onboarding everyone on the topic by giving 3 dots that for me are very important to highlight. And recently I heard Oscar-winning movie director Paolo Sorrentino from my own home country saying that giving an element, an object or a fact 3 times in a movie makes that element make sense, okay? So I was like, okay, then I have 3 things to say, and they all refer to one notion. We talked so little about the notion that it makes sense to give it 3 highlights, okay? And this notion is the public domain. And it's very counterintuitive that I open this conference where the big keywords are copyright and AI by bringing into the discussion public domain. Now, why I do that? Because I think in a very buzzing and lively discussion about copyright and AI, we have forgotten about the public domain. And I think we forgot to talk about public domain first and foremost in the phase of creation of AI. So we know in the room there are definitely more legal experts than techie people, but we grew familiar with what AI is or how it functions, right? In the fact that we are creating these software technologies, we are dealing but really crafting it from scratch. We forgot to learn some lessons about things we've been studying a lot. For example, the open source movement, or different types of ownership models, or asking people why you are developing AI, what is the incentive there, how much remuneration, how much reward, how much revenue you expect from this. We forgot to ask ourselves if AI is and will always be something that the private sector develops. I don't exclude that at a certain point, public sector or even the state will engage more in developing AI software. I think they already do. My research is just limited empirically, but I think that I wouldn't be surprised. We forgot to talk about or to think about public domain on the topic of today's conference. That is, when we look at AI training, and as legal experts, again, we get already lost because we don't know how AI is really trained. We don't know how to handle softwares in a practical manner. But we do know that resources in terms of content and information are fueled inside the AI. That's something we all understood, right? It was explained very well to us. And in that moment, in this moment of input of content into AI, that's something necessary for AI to be developed, we forgot to think and to increase the clarity and the care we have for resources that belong to the public domain. And I'm not just referring to the fact that we all know, my students for sure, that some works belong to the public domain because the copyright protection, this legal entitlement, expire temporarily. We know that. That's the classical version of public domain. And we know that these works are very old because copyright has a very long duration. So I'm referring to that. We forgot to think, now that we have AI in the room, do we want maybe to systematize better and valorize better those old works, right? Do we want to have a new database, sort of the experience we still have with Europeana, but do we want it also national? Do we want a national database where everything is clear that these works are free to be used, also for AI training? So we forgot to think about that until now. And we forgot also to think not just of public domain as the works whose copyright protection temporarily expired, but we forgot that public domain means so many other things if we just embrace a lato sensu perspective. It's also about actions, activities that are free to be done, okay? Over works that are protected. That's at least the public domain definition that I challenge my students with and I ask their opinion on. And on this, we also forgot to learn practices that we have been knowing and studying for such a long time. Ex-ante licensing, Creative Commons licensing, different models of handle the rights. Copyright exceptions and limitation is also a good examples, and today we will be talking enough about them from a European perspective and not only, but this is really something that reminds us of focusing on the purpose of a legal protection, and if the purpose sometimes is to have a free activity, then that purpose should also be optimized, and we forgot to do that. And the third and last point, I'm already talking too much, that's very common of me. The third point and the third moment we forgot about talking or bringing the public domain into the copyright and AI discussion is actually by forgetting to celebrate. In the same way our student last night celebrated their graduation, we forgot to celebrate that through this technology, we might have a flourishing of public domain works. We were very obsessed in trying to understand who has the copyright. This is something that this conference will not touch upon because it's more the output, right? But we still forgot to say, maybe we found a technology that can make public domain flourish, and we will be finally no longer victim of the chilling effect of, can I use this image from Google Images if I'm putting together a conference and I have to present this in Lisbon? We really missed or neglected the opportunity to think about that potential. And don't get me wrong, I do know that what I'm saying carries also a fair amount of economic impact in society, risks. I do know that embracing an idea or celebrating a flourishing public domain is not an easy task, but I'm just pointing out for you that's something we forgot to talk about until now. And right now, I've been mentioning public domain more than 3 times, but I'm not aspiring to win an Oscar for any movie. I'm just inviting everyone to use today's conference or today's moment all together as a discussion where we stretch our minds and we try not to forget something that is important for us in our legal studying, is our background ideas, in our urgency of doing something because we consider it important. We just have to fill this discussion with anything, not forgetting the points we consider particularly important or a priority to us. And to do so, we need to keep our mind very open to bring little pieces from all the jurisdiction and all the experiences we'll be hearing from inside our own little world. And to do that is really one of the best examples of what we do in academic research. And that's why the last word I wanted to allow myself to share with you today is we are having a little experiment here of bringing people together, high-profile experts on copyright law discussing the topic, and opening the discussion to try to find new ideas on this, right? Not to get stuck. And this is literally, for me, the definition of scientific research and what we are trying to do here at Nova School of Law. And I invite everyone in the room, in your own role, in your own capacity, to keep supporting scientific research, because the scientific rigor behind this exercise of thinking and studying and exchanging this sort of idea is really something not to underestimate. And on this note, I am particularly grateful to projects like the Consumer Empowerment project that really set as one of its core objectives supporting scientific research, whatever that means, right? So I invite everyone to be more proactive in that supporting, and I really thank this project and Marco as coordinator for being a pioneer also in doing so. So that said, I'm really not, you didn't fall prey of my own talking and teaching. I'm introducing to you Marco because we've been referring to him now a couple of times. Marco Cialdone, besides being a friend of Nova School of Law that travels and pops by sometime regularly by our school, is the head of litigation and academic outreach at Euroconsumers, is the director of the Consumer Empowerment Project, on which probably will explain a little bit more, and is also adjunct professor at the European University in Rome. So, Marco, without any further ado, big thanks from us and welcome back to Nova.
Well, thank you. No, thank you. It's an honor and a pleasure to be here. I mean, it's the third time, I think, in a month I'm becoming kind of familiar here at Nova. And no, I mean, I really appreciated your word because, okay, so you are projecting the presentation. I was supposed just to give a presentation about the Consumer Empowerment Project, but then Giulia assigned me 15 minutes and it was too tempting not to speak about copyright. Actually, I remember that the very first course I taught at university was on digital copyright. So I will take, I would say, 2 or 3 minutes to speak about the Consumer Empowerment Project and 10 minutes just to some reflections about the topic that we're about to discuss today. So talking, I don't know if this works or not. No, maybe not.
Oh, yeah.
No, now it's working.
Yes. You just pointed
Okay,
in the
okay,
computer
now it's
direction.
working. Okay. So The CEP is an initiative that we started in April 2022 together with Google. So it's supported by Google and by our consumers. And the idea at that time was to create this kind of safe space for collaboration and space where consumer organizations, civil society, industry can come together and discuss the most critical issues regarding the consumer empowerment with a specific focus on the digital transition. And the keywords that we decided to use at that time was the power of dialogue, because this was exactly what we were looking for at the time. So to create something that was empowering different stakeholders to dialogue together. And from that moment on, we maybe you can pass to the next slide. So from that moment on, we put in place several activities. The first one that you see is one of activities that we did here in Nova. The third edition of the Consumer Leadership Academy took place here in Nova in November last year. And then we have our Consumer Digital Empowerment Index, which is an index to measure the empowerment of consumers through digital tools. The My Data is Mine award, we have here today not only one of the first recipients of the next project, so the scholarship that we established with CEP, but also one of the winner as a special mention of My Data is Mine award of last year, Amanda. And so the My Data is Mine is an award that we established in 2020, so before the Consumer Empowerment Project, to support young researchers under 35 in the field of data protection. And we present every year the winner here in Lisbon at Web Summit, and so will be this year in a couple of weeks. Then I would like to mention the most recent projects that we started. One that I'm really proud of because it was a kind of an important decision that we took was to support PhD scholar. And so we established this CEP scholarship. I think you can pass to the next slide. And we selected through a call of expression of interest different universities around Europe. We focused on the country where the Euroconsumers Group is present, so Belgium, Portugal, Spain, and Italy. So we selected BOB and Leuven in Belgium, Católica and Nova here in Portugal, Siena University in Italy, and the Autonomous University of Barcelona in Spain. And this is a way to support the research providing grants to PhD students. So I'm really pleased to see that one of our PhD scholarship recipients is here with us today. So it's a kind of testifying the importance of this project. And you can go to the next slide. And this one is, instead, it's something that we started actually yesterday, 2 days ago, someone. And this is something that we are doing with the schools in Italy and Spain, is just to empower the citizen of tomorrow. So just to provide some kind of basic knowledge about how AI works in a context of primary and secondary schools. And starting from 2025, we would like to launch the project also here in Portugal and in Belgium and Poland. And finally, so the next slide, we have this kind of moment, which we call the CLAs. CLA is the acronym of the Consumer Leadership Academy. So we decided at a certain moment to create this moment between one academy and the other. We just had the 5th edition in London a couple of weeks ago to keep the dialogue alive between one academy and the other on some specific topics that we consider relevant in this moment. And of course, the interaction between AI and copyright is absolutely relevant. So this is the presentation about the Consumer Empowerment Project, and of course feel free to reach out to have more information. We have the site cp-project.org, and I mean, talking about the topic that we are facing today, one thing that I would like to say especially to the students, that every time you are told that especially in the copyright domain, but also in other domain, that this is something completely new. This is a new legal challenge that we never faced before. Probably it's a lie. Because history tends to repeat itself, and especially in the copyright domain, copyright has a long relationship of love and hate with the technology. And so I will show you 3 examples. I didn't know the point on the 3 dots of Sorrentino, but I use this 3 example. So if you can see the next slide. So coming back to 1839, so the gentleman that you see on the left is a painter. His name was Paul de la Roche, and on the right side you see what was called at the time the daguerreotype, was the predecessor of the camera. So the Chronicle of the time said that he said, from today painting is dead, the first time that he saw this kind of machine. Of course, painting is not dead, but in a certain way he was right, because he was referring not to painting, but probably to a change in the market. Because up till that moment, he was a special kind of painter, he was a portraiter. Till that moment, the only way you have to keep the memory of someone that you love was having a portrait, and you need to buy the portrait from a portraiter. So this was his job at that moment. Imagine what it happens when in the market enters a machine that can produce what you do with the sweat of the brow of several hours in just 10 or 15 minutes at that time. So it was a big and huge change in the market. And from his point of view, painting is dead at that moment, because he needed to face a revolution also in the consumption behaviors of his clients. Moving fast forward in next slide, in 1906, I don't know if it's working. Maybe. No, I don't think it's. Yeah, it's the next one. So it's in 1906. If we go to this next slide, there is this picture of this gentleman. I mean, the story is, if you have read the remix book of Lawrence Lessig, this is John Philip Sousa, and he was also a musician at the time. And so if you go to the next slide, he was asked to testify before the Congress at the time to speak about, so we are going, maybe. Sometimes it works, sometimes it's not. Okay, now it's work, I'm doing it. Okay, so it's great. So he was talking about another new technology at that time. So that's something really new, something that could produce music without the need of a musician in the room. And of course, he was terrified by this technology. So this is the words that he pronounced before the Congress: this talking machine will end up ruining the artistic development of music in this country. When I was young, in front of every house on summer evenings, you'd find young people singing new tunes or the old ones. Now you can only hear these infernal machines going on day and night. We will lose our vocal cords just like humans lost their tails in the evolution. Again, we didn't lose our vocal cords, but he was referring again to a change in the market. So till that moment, if you want to listen to music, you need to have a musician in the room. From that moment on, you didn't need the musician anymore in the room to listen to music. So it was a change in the market that was really frightening for him. And the third example is 1982. You remember the video recorder. Also, there was a huge legal battle in the US. I tell you one thing, the video recorder is to the American film industry what the Boston Strangler is to a woman alone at home. This was the sentence attributed to Jack Joseph Valenti, at the time the president of the Motion Picture Association of America. Again, it was not exactly a strangler to a woman alone at home, but it was referring to a huge change in the market. Till that time, if you want to see a movie, you need to go to a movie theater. from that time on, you can watch the movie at home. But the change in the market was something that lead to the blockbuster industry, for example. So again, it was referring to a change in the market. And coming, so after these three examples to what's happening, no, it doesn't work anymore, I don't know why. It's the technology, because when it's the technology against. So you have, you face the same situation nowadays. So in November last year, you have the Hollywood actor strikes because AI is stealing their job. And just last week, this was this declaration signed by Radiohead, Robert Smith, and other artists protesting the unlicensed use of creative work in AI training. So you see, maybe the assumption is that we are again in the middle of the 18th century, or at the beginning of the 19th century, or at the end of the 19th century. So basically we are facing again a technology that is changing the market, and the reaction is exactly the reaction that we saw happening already in the past. So what is the solution and the most important topics of discussion? Giulia anticipated this topic. So the first one is not something that we are about to discuss today. And just to close my intervention on that, probably we will hear different kind of position and different kind of approach in the legislation. Because in this moment, you have at least 3 different doors before of you. So one is the European approach with the text and data mining exception, and we also had this very recent decision by the Court of Hamburg and the first kind of interpretation of it. And then you have the USA approach, which is basically based on on what extent fair use can be applied to the AI training. And then you have this very peculiar approach of the Japanese legislation, which, if I'm allowed, I'd like to show you I like a lot the title. Of course, this is a translation. I like a lot the title of this article of the Japanese Copyright Act, because it's one of the exceptions in the Japanese Copyright Act. But the title, I think it's beautiful, because it's the exploitation without the purpose of enjoining the thoughts and the sentiments expressed in a work. Because, I mean, this is really the core of the copyright protection. What is protected and what is in the public domain, because it doesn't affect the real use of the work. So it was really a nice one. And just to end, and this really complement what Giulia was mentioning, in 2007 there was this beautiful paper by Professor James Boyle, the author of the beautiful book Public Domain, that was titled Cultural Environmentalism and Beyond, because in front of the change that the internet revolution was bringing in the domain of copyright, he was asking to himself if there was a need of a kind of environmentalism of culture, so the need for an approach that create an environment that was good for culture and good for copyright, also through private law instruments like, for example, the Creative Commons license. Maybe we need a cultural environmentalism 2.0. And so I stop here. Thank you.
Thank you very much, Marco. I think this was not staged, even if probably it could have, but this was just a complementary joint keynote speech. So next time we organize something, I think we should not stage it, because it just flows so naturally that what we say really reflect the two faces of our efforts, also professionally, and that's very nice to see. So without any further ado, and I apologize for not inserting coffee breaks and moments where we can just stay with our own thoughts and relax our brain on so much input. I just will pass the floor to our distinguished speakers of the day, and then we will conclude with some final remarks, and we will have food and moment and time to really stretch our mind and continue the discussion more informally afterwards. So the first speaker we have today, and it's anticipated, we invited them to bring specifically national legal perspectives, insights, but giving all the freedom to really explore the topic as they felt more fit. We have as first speaker of the day a dear friend of mine, Carrie Craig from the University in Toronto Hall Law School. She's full professor and director of the LLM program in IP Law. And I like to introduce her to you also as one more example of legal lecturer and legal expert that combines this research and teaching not only in your own private experience of your work, but also getting people together and finding this teaching and research component as a collaborative experience. So she also founded something that Nova IPSI looked up to and got inspiration from, the IP Osgood IP Law and Technology project, which has this collaborative component of creating teams of minds and looking at intellectual property as something that requires more discussion. It cannot be a solitary act of research by some people that then convene together in conferences once every now and then. So Carrie, thank you so much for being with us today, and the floor is all yours.
Wonderful. Okay. I'm going to see if, well, we'll see in time if this works. Is that going to, are we okay?
Yeah.
Okay. And everyone can hear me okay? It's there. Got it. Okay. Well, thank you, first of all, for the invitation to be here. It's just a delight. So thank you for all the work that you're doing, Giulia, to bring people together. And thank you for the honour of including me today. I am talking about Canada, but I have a Scottish accent, so that may be confusing. I know more about Canadian copyright law than I do about the UK, but I also appreciate the invitation to provide a sort of comparative perspective, which I think we've been somewhat missing because we've been in our own sort of silos in terms of the approaches that are being taken to this important question. So let me just begin by saying it is true that we're living in what the late Dan Burke called an age of mass synthetic creativity. Right? And so if we think about it in those terms, it's hardly surprising that the law that protects creative expression, because that's what copyright does, that law has been launched into what I think we can call a fresh kind of existential crisis. Right? We have policymakers, it's had existential crises before, over time, as you nicely explained, and this is the latest one, right? We haven't had one this serious since the age of, or the arrival of the internet, I'm going to say the World Wide Web. And the days of Napster, which probably there are a few people in the room that remember, but it was very exciting at the time, and I feel that we've been launched back into a very similar conversation all around the world, and Canada is not an exception to that, of course. So I'm going to talk about the current debate in Canada, and I think what's interesting about it, maybe from your perspective, is that the law in Canada has not yet responded directly to the advent of artificial intelligence. So we remain at something of a crossroads in the law. All of our eyes are trained on the US and on the EU at the same time. And so for those of you as well who just haven't thought about Canada in this context, or maybe just not much at all, which would be fair, I also want to mention at the outset why it's such a fascinating jurisdiction to watch. And I say this as a Scot who went there to study and just found it fascinating, in part for this reason, which is that it has the UK origins that mean that it has all the sort of Anglo-Commonwealth influences in the sort of history and the origins and the development of the law. But at the same time, It has Quebec as a Suisse jurisdiction, which has influence on the development of jurisprudence and certainly on the politics in Ottawa, right, where bilingualism is key, and so the French influence really flows into Ottawa. And at the same time, of course, we're perched above the US, right? And so our major trading partner, our biggest border is with the US, and so we can't act obliviously to what is happening there either, and we're subject to some powerful trade dictates from south of the border. So in this way, I think Canada is just a fascinating kind of epicenter where you see these various sort of cross currents of thinking and theorizing and politicking around copyright really come to bear in one place. Okay, so with that said, it's done, got it. While concrete steps have been taken, did I skip twice? Yeah. While concrete steps have still to be taken, as we'll see, there's been quite a lot of discussion, a lot of public consultation on this issue. The controversies and the confusions around generative AI and copyright are looming large in our policy discourse. So from the fake Drake to the Drake deepfakes. Yes, Drake is Canadian, by the way, he's from Toronto, if you didn't know. There were lots of discussions about what was fair. There was also some outrage over the apparently revelatory story that the works of great Canadian authors like Margaret Atwood's were included in the Books 3 database that had been used as the basis of training for OpenAI and several other major AI systems. So that sort of hyped up the rhetoric around AI. And copyright. And then in practical terms of what we've seen is that there's really much more in terms of media stories and public dialogue than there is actual movement in the law, reform, or litigation. When it comes to litigation, we're watching all of the cases that I think the world is watching unfold in the US, and my sense is that Canada is reluctant to move or do anything before it knows which way the US is going to move. So in Canada, we only have one copyright case so far. It's about AI. It's not really about generative AI. In fact, the image on the right was made just using old-fashioned photocopiers and scanning machines, scanning one another. And then AI was used with a database to do a sort of declaration of matches with existing human-created works. And so that was interesting, but it wasn't really, again, about artificial intelligence. The similarities were coincidental, and also the case was settled. So we didn't get many real answers from it. On the other front, Canada has this dubious honor of being one of the first countries to register an AI-generated work. And indeed, we registered this work with the artificial intelligence app, the Raghav AI painting app, listed as the co-author of the work, complete with an address and everything, as though that's the place that AI actually lives. Of course, the AI doesn't live, and for that reason, I would suggest cannot be a joint author. The good news is, in Canada, we don't have a substantive evaluation. When you get an application to register, it's just registered, and we don't need a deposit, you don't evaluate the claims. But right now, the University of Ottawa and its CIPIC group is moving to challenge this registration. So there is a lawsuit pending. Oops. There is a lawsuit pending.
I didn't make it in the slide.
You're right. Sometimes it works, sometimes it doesn't. Okay. Wait, was that too? Yeah, there's a lawsuit pending where we are challenging in the federal court the validity of that registration, which is something we don't normally bother to challenge because in Canada registrations are all but irrelevant, to be honest with you, in terms of their legal significance. It's not like the US. They don't have particular legal significance, but nonetheless it's on the register saying something that we think just cannot be legally accurate because an AI cannot be a joint author. We will see. We've also had lots of consultations, more than enough. Next. I'll just say next. Nope, there. First one. So we had a 5-year copyright review from their most recent amendments to the Copyright Act, and that was in 2019. What was interesting about this is that we barely really talked about AI at the time, just a little bit. A few people showed up and testified before the government, and the government thought it was an easy case. The government decided, or at least the committee recommended, oh, we should add an exception for informational analysis of works. Obviously, no big deal. And they also suggested in their observations, maybe if it's a lawful access issue, that would be fine, but otherwise just a general exception for informational analysis, which would include text and data mining and presumably the training now of AI. So that was the last word, and then in 2021 we had a consultation that directly asked this question. And actually, more specifically, it said how the question that was posed was how should the government continue to achieve copyright's underlying policy objectives in the face of AI? And asking then again about text and data mining exceptions. Here, I managed to get together 14 Canadian academics, or a group of us did, and we wrote submissions that basically said, we support the government recommendation for an exception for informational analysis. And everybody was pretty much on the same page. Only about 38 submissions were received overall. And those are later summarised in a report as saying, stakeholders from the technology sector, scholars and user groups generally argued for a text and data mining exception, but the creative industries were generally of the view that the new exception was not desirable and would prevent rights holders from receiving fair compensation. And so the government then returned to the question in 2023 and launched a third consultation, essentially, specifically on copyright and generative AI, pointing to the growing awareness of AI since the arrival of ChatGPT. And kind of like, you know, when you say to kids, like if they don't like the answer they get from their mum, they ask their dad, or you just keep asking the same question again until you get the answer you want. So we've kind of done it this way. So now we have many more submissions, and actually, of course, that means there's more involvement, but there's been a lot more organisation, a lot more industry lobbying has been directed towards participating in the consultations. And now, of course, there's even less consensus than ever there was. So apart from having this consultation fatigue and opening the door to lobbyists, I think what struck me most about the consultation paper, the last one, was a complete shift in tone and in the framing of the issues since we began talking about this in 2019. So it was, in considering the policy objectives, the government paper said, we'll aim to balance two main objectives. One, to support innovation and investment in artificial intelligence. And two, to support Canada's creative industries and preserve an incentive to create and invest, provided by the rights in the Copyright Act and the right to be adequately remunerated for the use of works and other subject matter. There is, incidentally, no right in the Canadian Copyright Act to be adequately remunerated. It just doesn't actually exist as a right, but nonetheless, this was the balance that the government articulated here. So what I'm going to do is return then and give you all the Canadian Copyright Law 101 lesson, and maybe I'll give the same one to the people who will be thinking about this in Canada as well, hopefully at some point. So we have actually a wonderfully rich body of jurisprudence that reflects those sort of cross currents that I was talking to you about before. And this all began really in the Théberge case in 2002. So that was very, very instrumental in articulating the purpose of copyright law for this century, and it has really developed over the past couple of decades to sort of instantiate this idea that copyright must be a balance, and that part of that involves protecting the public domain and not just private owners' rights. Part of it involves protecting users' rights, and that's really central to the purpose and the primary objectives of the Copyright Act, not something that's secondary. So you'll see in the words of the Supreme Court of Canada in Théberge that copyright is about protecting or encouraging a balance between, promoting the public interest in the encouragement and dissemination of works of the arts and intellect, and obtaining a just reward for the author. And it's the balance between these that matters. It also means then that you have to not only recognize creators' rights, but you have to give due weight to their limited nature, right? And then it's in subsequent case law explained that when we face new technological challenges, what that means is what we're trying to do is maintain that traditional and appropriate balance between authors and users in light of the new technology and its affordances, what it allows you to do. So if we look again at the balance between, You go, okay. Look again, this is just the same slide, so it doesn't really count. But you can see what I've highlighted again, right? This is like the balance that the Canadian government was talking about makes no mention of the public interest side of the balance. It doesn't mention encouraging the dissemination of works. It doesn't mention the public domain. It mentions protecting the rights for two different industries, the tech industry and the creative industry. That's what's in the balance, right? And so we're moving away, and that's why I'm worried about where this process is going to take us. Okay, back to Canada 101. That also then, this balance in tape errors was used to mean that, first of all, we had an elevated definition of originality that flowed from it that really requires authorship, skill, and judgment. It placed limits on liability for people who offer new technologies, so authorization liability was limited. But here you see in this quote, it recognizes the importance of the public domain. Right, that we cannot, you have to respect the balance so you don't unduly limit the public domain. Similarly, well, let me say that means the elements of the public domain, ideas and other unprotected elements within works, must be free for all to draw upon. Okay, that's in the Robinson and Steinar case. And then we have the famous CCH case in 2004, which is about specifically the role of fair dealing, or limits and exceptions in copyright, and describes these as user rights. Okay, user rights that must be recognized, that are not just loopholes, but are central to recognizing and realizing this important balance. Most recently, in 2021, looking at a fair dealing case in a university context, the court reiterated this clear concern with dissemination, with the availability of works, and I think the language is not even an accident in 2021, those availability of those works as a source of tools and inspiration to generate works by others downstream, right, in furtherance of copyright's primary goal. So that's a proper balance that ensures that authorial control is not privileged over the public interest. Okay, so that's our Canadian copyright landscape, and that's what I want to hold on to. I want to now skip through some of these more doctrinal points to see how this frame can inform how we'd apply the law. I'll try to spare you the details, but my suggestion in general is that these principles already give us what we need to be able to actually critically assess and think about how the law should apply to the use of works when training AI. And for the most part, just, the spoiler is, I think that work should be free to be used for text and data mining, informational analysis, and the training of AI. So let's see how I get there. We do have a very broad reproduction right in the Canadian context. So there's the sole right to reproduce the work in any material form, whatever, which kind of means, and has been taken to mean in the jurisprudence, that as soon as you make a copy, even if it's just a digital copy that no one ever accesses, that copy is relevant, right, for copyright purposes. I think that's a mistake. It's funny, back in 2004, looking at caching, where copies are made when you're just browsing the internet, that kind of caching, the court thought clearly just should not. It's just a technical reason that the copy is made. It shouldn't attract copyright liability. But unfortunately, in the Sodrak case in 2015, we stepped away from that and said any incidental copy is a copy. I do think we still have some arguments, and these are not just limited to the Canadian context. I would make these in any context, that this is not something that implicates copyright, that it should be just a copy that's sort of besides the point for the copyright regime, at least in the database, like in the training materials. And so that is basically to argue that the use that's being made is a functional use. Right? Remember what the Steinar case said about the limits of the copyright work, the elements that belong in the public domain. Copyright doesn't protect functional elements, it doesn't protect data, information. And so the use, I would argue, is sort of a de minimis use of unprotectable elements of the work, and to protect it in that context, I think would upset the copyright balance in a way that violates the principle of technological neutrality apart from anything else. So I would probably stick by that. It means that I actually like as well the Japanese exception that was on the board before. So I'm glad you had the opportunity to see that, right? And this is the argument that I've made elsewhere. Basically just that the use of the work is use of the work as a functional thing. It's not use of the work as a work, as original expression, and so it's not use of the copyright work as such. We say the same in trademark law. If you don't use the trademark as a trademark, it might not implicate trademark law. We should do the same here. And this is the argument that Matt Sag is making about non-expressive, non-consumptive uses. Séverine Dussolier is arguing as well about the nature of the copyright system as one that's concerned with authorship and expression. So protecting this kind of use seems to sort of step outside of or distort what copyright is about. And I agree with them. Okay, so this is, that's the quote there that you can see from Matt Sag and from Dussolier. I'll just add to it as well. I've written quite a lot about how the AI can't be an author, and I've already said it. I think the AI can't really be a user either. The machine itself and its processes is not using the work. It's not a recipient of the message. It's not an audience of the expression. And I think we should begin by recognizing that too, and it goes hand in hand with the idea that authors and AI are not the same thing. Okay. If I'm wrong about this, or people just ignore me, no matter how right I am, it happens, then I still want to argue that, okay, there should still be a defense in the law as it exists, right? And sorry, I'm getting close to time, so I'll keep this quite quick as well. But you'll remember what I said before about limits and exceptions as user rights in the Canadian copyright system, central to the balance. So we have some specific exceptions in the Act for temporary reproductions, for incidental uses. We have non-commercial user-generated content, so that could go some distance. But I still think the best hook to hang this on is going to be fair dealing. And fair dealing, we have the sort of UK model where you have a restrictive set of enumerated purposes that you have to fit within. So it's not an open-ended fair use defense that you'll be hearing more about. But the question really is, well, is it research? Could we say this is fair dealing for the purposes of research? And if we can get it, or even education, I guess, if we can get it into that purpose, so it fits, then we just conduct a fairness analysis. And then it is just the same as the US fairness analysis. We have the same factors. You can see how closely they align, or you will, to the US fairness factors. So I think if it is fair in the US, we're going to arrive at a conclusion that it's fair in Canada. And in fact, in Canada, we say the fact that you might have been able to license it, or a license was available, is not relevant to fair use, right? It doesn't make it more or less fair that you could have licensed it. If it's fair, you don't have to license it, because it's not an infringing use for which a license was otherwise required, right? And so in fact, it could be a more generous fairness analysis than we see, or than we might end up seeing in the US. Okay. So let me just quickly say that post-Tay-Berge, the jurisprudence has an expansive understanding of what research is. It must be given a large and liberal reading. It can include many activities that mean that you're making new works. It can be piecemeal, informal, exploratory, confirmatory. All of these things can fall into what constitutes research. And so I've argued that there is a good reason to assume that for the most part, text and data mining, even without any additional reforms or amendments added to the Act, could benefit from the Acts as they're currently construed. Okay, people disagree with me. So I should say that there are submissions that went into the government consultation, and you can see a few examples here from copyright collectives, from organised industry actors, basically saying, no, there is no exception, copyright is implicated, and by the way, don't add an exception, right? So we're going to see how it goes, but my fear again is that we're moving in the wrong direction right now, and actually what's going to happen is that we're going to have a sort of knee-jerk response to the arrival of this new technology. We're going to respond to the industry actors who are lining up to advocate for their own interests, and the public domain, the user rights, the copyright balance is likely to be lost somewhere along the way. So that's my fear. I'll just say, for those of you who might still be thinking, well, I'm not sure about AI, I'm not sure that I want it to develop the way it's going, I don't much like the AI slop that we're generating right now, and the risk that it poses to our cultural ecosystem. I've argued most recently that we really, if we're worried about this, that copyright is not the right place to look for solutions to regulating AI or reining in AI, that what we'd really be doing is kind of reinforcing our intellectual property's private knowledge systems, private transactions through in the marketplace, and failing to have sufficient regard to the cultural ecosystem, and that's ultimately, I think, doing more harm than good. Thank you very much.
Thank you so much, Carrie. So this really embarked us on a journey of a lot of information that needs to be somehow digested by setting the right focuses. And I think this also helped a lot moving, or for the audience today, understanding also the line of the speakers today, because it's true we look at different jurisdictions, but Carrie's right now just set the tone by pointing at very important key elements of this discussion. So I really appreciate the fact that we are talking about functional use, and when we talk about use, we need always, from a copyright legal perspective, to see which use are we doing. So it's just a reproduction, or is a communication, something that we will also look at with Salvatore, the European scenario. And you also used or shared with us the Canadian wording of informational analysis. And this is very interesting for us, because even though we are here in a deep copyright legal debate, we are dealing with a subject matter that sometimes oversteps or finds also regulation outside intellectual property and copyright. So Canada and Japan are just the first highlights we wanted to give, to now pass to EU and US legal scenarios where we have the feeling we know more about it. That's something that we have been working with a little bit more often. At least in the room, I see people that have studied and worked with this sort of jurisdiction, just out of the fact that we are based in Portugal, so EU law is something we followed very closely. And somehow, for the final two presentations before our closing remark, we stay in the UK and we stay in Palermo, because we have Salvatore Fasciana with us, who we invited from the University of Sussex, where he is a lecturer, and we stay also in the same research vibe as Rossana Ducato, in the sense that Salvatore has been focusing on intellectual property in his professional career, both as an academic and as a qualified lawyer, but also implements the information technology law as a dimension. So we invited him to present the EU legal scenario on text and data mining specifically, or how he would approach this topic, by combining these and bringing us, if needed, also outside the copyright technicalities. So Salvatore, thanks so much for being with us, and I leave you the floor, and then we'll pass to the last one.
First of all, good morning, everybody. Thanks for being here, and thanks, of course, to Giulia for inviting me. And first of all, I would like to say that I'm appreciating a lot that Carrie's presentation and Rossana's presentation are already like drawing a net of principles that we can already, let's say, observe and just start to link to each other. And then I think that I hope my presentation will add more aspects in this sense, and we'll see other connection and further connection. And also, I would like to take a piece of Rossana's presentation where basically I think that the EU perspective is absolutely amazingly placed in this panel, because it comes after the Japan. And if the Japan is the paradise of TDM, if I'm Virgil and this is the Divina Commedia, I would like to bring you not for sure in paradise, but not even in hell, let's say purgatory, and let's say something like that. So let's start. Yeah. I'll start. Well. So thanks so much. Is it okay if we just say next and we do it, because I don't trust the technology. So thanks. Okay, I don't know if you remember, especially right after the GDPR came out, but we read a lot of this sentence, data is the new oil. I don't know if you remember this phrase. And I think that this was the right, let's say, moment to revisit, not only because I started getting bored by this expression, but also because I think that data is more about a mine, and the knowledge is actually the gold or oil, if you want to look at it in this way. Basically, our digital data information, I like to call it attention economy for certain reason, basically relies a lot in basically the processing, the recombination, and the extraction of knowledge from a large amount of information and data. And in order to basically identify patterns, correlation, relationship between this information. And the main purpose of this is basically extracting knowledge, which is basically one of the oldest, let's say, good that we had since the ancient time. And text and data mining basically allows for this. This is why text and data mining is so important. And given the, let's say, very recent advancement in technology with generative AI, machine learning, large language models, we now understand even more the importance of text and data mining, because this is basically becoming a crucial aspect of generative AI. Without text and data mining, we cannot write, I couldn't write certain prompt on ChatGPT and having this type of images that I'm showing you today. So I think it's a crucial aspect of the future of the technology, of the future also of the jurisdiction that implement this technology and the related legal framework around this technology. Next slide, please. So let's start by, I would like just to give you a perspective, a European perspective, and also I would like to bring this perspective in a broader, let's say, position, because yes, we have the definition of the Digital Single Market Directive about text and data mining, and any automated analytical technique which aims to analyzing text and data in digital form. And I would like that you start appreciating the very broad definition of this. Also, not only the directive define this, but also the recital, which basically said new technologies enable the automated computational analysis of information in digital form, such as text, images, sound, like text and data mining. So I thought that it would be useful for everybody, maybe just to understand, just very generally speaking, what is text and data mining, how actually does this work, okay, and why this is important for copyright perspective. So here I prepared like a very broad scheme, and basically text and data mining works throughout three main steps. The first step, if we can go to the next slide, please, thanks, is the access to content. The second step is the extraction and or copying, of course, of the content, and then there is the mining process, which is actually the one that is dedicated to the knowledge production. So the first step is basically represented by the raw data, the rawest form of data that we can think about, okay? Then there is the first step. The first step of text and data mining means that there is the access to the content. And in this context, we deal with different type of data. We deal with, for instance, target data, which is basically the type of information and patterns that the whole text and data mining is designed to create. So this is our target. That's why they are called target data. Then there is the pre-processed data, which is basically a set of information that's undergone a process of basically polishing. So basically the data get cleaned, gets basically all the mistakes, all the integrity issues about the data get basically rid of with this, so get eliminated in this step. And so that the data is reliable and it's consistent throughout the process. The second point, which is the one we need to be aware, because this is the one that where copyright law is involved, is the extraction and or copying of the content. First of all, and we will see later, just briefly, because I included some example, not necessarily all TDM, all text and data mining involves copying or extracting content. It depends. And here we deal with a different type of data, the transformed data, which is basically we convert the pre-processed and the raw data and the target data in something which is very good, perfect to be analyzed during the last step of the TDM process. And then there is the third and last process, which is the creation of patterns and pure knowledge from what we have found out so far in the first two steps. Next slide, please. So, in the European Union, text and data mining are treated as an exception in the Digital Single Market Directive, Article 3 and 4, as Rossana kindly showed in her chart. And briefly, basically, it's nice to see that the legislation objective was, of course, as usual, targeting the internal market purposes, which is basically a very common trend, especially in IP directive. And also, I would like also to show you that it's important that, like, let's say that the whole directive was also in order to create a framework in which the exploitation of works can work in other protected subject matter can take place. I show this because there is a irony after that, because I don't think it's actually very respected in this sense. So basically we have Article 3 and Article 4. The Article 3 quite broadly basically allows a certain institution, specifically research organization and cultural heritage organization, to undertake TDM, text and data mining, purely for research purposes. Then, after the first proposal, which was, of course, involving all the Article 3, committees and reports, basically they thought that it might be good to expand a little bit the text and data mining framework, and we have Article 4, which basically doesn't really target specific subject. Everybody, it's available for anyone. The only problem is that the copyright holder can basically opt out from the consent, because the text and data mining can only happen through the consent of the copyright holder. If they opt out, if the copyright holder opts out from this permission, let's say that the Article 4 is almost void. Next slide, please. And basically, these are the Article 3 and the Article 4. These are very slow, roughly what's happening now. Research organization, cultural heritage institutions. It's important that scientific research involve both natural and human science. And some aspect of the Article 4 about the opt-out is that the opt-out should be performed in an appropriate manner in a machine-readable format. Okay, so more or less this is the situation. However, next slide, please. We can identify certain issues about these two articles together. First of all, as I said before, we have a very broad definition of text and data mining. Basically, every single technology which is able to analyze digital text is considered text and data mining. This means that there is the risk, to some extent, to expand the text and data mining exemption to certain technologies that they shouldn't be there, to some extent. And this means also the risk, as we will see, and as also we already heard from previous presentation, there seems that we are starting basically allocating property rights on data and information, which is something that we don't really want to do. On the other side, on the second point, the beneficiaries of this, because it's a very broad definition, but it's very narrow in terms of who can actually exert this process of text and data mining. I told you, of course, cultural and heritage institution and research organization, which means that even though the previous, let's say, corporate form of OpenAI was a non-profit, okay, debatable, but it's very hard to think about a company like OpenAI doing what it's doing right now, doing the same here in the European Union. And of course, the Article 4, it's also a bit, let's say, of course it's a hope because it's something that is broad, is open to everybody, but at the same time it's very easy to void this article because it's just enough to opt out from the copyright holder, which means that it's very, let's say, dependable. Of course, I wouldn't feel very confident that my text and data mining process can rely completely on this Article 4. The rights, because it's important to observe that the text and data mining exception involve only the right of reproduction. This is a problem because, we can have a problem especially for the AI and how the AI works, because if we cannot publish, communicate certain information to the public, then especially the aspect of, probably you know, the aspect of black box and the aspect of how AI generates certain type of information cannot actually come out and be published and then, let's say, enhance the understanding of this technology. And also the contract, because yes, we know that we can limit, it's impossible limiting the TDM exception cannot be limited by a contract, especially in the Article 3, Article 4, yes, of course. But it's an interesting point to observe is this limitation is not actually taking place to a contract, but through the code of the same, for instance, of the database. In that case, it's something that would be basically on the shoulder of the user to basically fight to regain the right to use the text and data mining. Next slide, please. So, and this is where I would like to bring you, because it's interesting that in a document of the Commission, the European Commission, we have a clear communication that researchers, they don't feel very confident that they can actually undertake text and data mining in the European Union. And the reason is because the, let's say, multi-layered and complicated member states copyright framework. And first of all, it's important to say that not all the time, copyright is involved. As I said, it depends, because some TDM processes, they do not involve copying or extracting aspects. So, for instance, the frequency analysis of phrases, so they are analyzing how in the, let's say, the publishing dates of research articles. They do not involve copying or extraction. And also, if the TDM is considered under the 5.1 exemption of the InfoSoc directive, everything is safe. However, if we can have the next slide, copyright seems having a lot of overlapping with the TDM exemption. Because first of all, we need to have the assessment under the Article 5 of the InfoSoc directive. And we know that it's a non-mandatory exemption. At least the first one is mandatory, but the rest are not mandatory. And they're also very narrowed understood, which means that we need to check if we have this process, whether or not they would pass the assessment under the Article 5.1, 5.2, 5.3 on top of the database directive. Then we have to understand, and also as Kerry said, the right of reproduction. We have an understanding of the right to reproduction which is broad, overarching. Basically, everything has a reproduction in the European Union, and basically everywhere. And also, we have another aspect, which is the concept of recognizable, which was first found out in the context of phonogram, but this can be extended. I mean, it's not forbidden to think that this can be expanded, and this concept of recognizable can be interesting in the context of TDM, because if something is recognizable in the output, well, it's a problem, or might be a problem. On top of this, we know that for a database holder, even though the database is not protected by the sui generis right of database and copyright, the database holder can actually treat this database as he wants. So it means that he can protect the database in certain ways. And under certain conditions, there is also the publisher rights which can be involved. So it's not a paradise. I would think it's not a paradise so far. Can we have this next slide, please? So, and this brings us to the bigger framework where TDM is accidentally, I think, placed, because it's a copyright framework. And European copyright is featured by a very low threshold of originality. We know the famous 11 words of Infopack. We know that there is a broad interpretation of the right of reproduction. And we know that we have a list of non-mandatory exemptions which must be interpreted in a very narrow way. All these elements combined, especially with, and also I was forgetting, the recital 44 of the InfoSoc directive also clearly states that with the advancement of technology, the interpretation of exemption can be even further limited. And which means that we are very close to structure a system where basically mere facts and data, they are protected, even because we have a very low originality threshold. They can be protected. And we know, because we know very well that the expression dichotomy, but we also have the fact expression dichotomy. We know that copyright, as previous conversations, previous presentation already exposed, we don't protect ideas. We don't protect ideas, but we don't protect mere facts and data. And we know it from, for instance, case law, from the Brompton case. We know it, for instance, the database directive, which clearly states that the right to prevent unauthorized extraction and utilization does not in any way constitute an extension of copyright protection. We know it, it's there. Also, the same recital of the Digital Single Market Directive states the same. Next slide, please. So what's happening here right now is that Article 3 and 4, they are narrowing down even more the exemption, the potential power of the fact expression dichotomy. And basically, what's happening here is that when basically it seems that mere facts and data, they receive an indirect protection, which comes directly from the protection that we offer to the subject matter in the work where they are included. Basically, if we get information from a container which is protected, but the information are not protected, it seems that the information and facts, they get the protection that we give to the container. And this is a problem. And this is a problem because they are not protected. They shouldn't be protected. They are in the public domain, to link to what Giulia said earlier. So it's important, and also, of course, this with a very broad right of reproduction, if it doesn't really feel like a paradise so far. And it's something I would like to show you, but if you look at the Article 14 of the DS, or the Digital Single Market Directive, the Commission was very clear to say that there was no copyright infringement in a specific aspect, which was about visual arts work, if I'm not wrong. We would appreciate something like that for TDM. It was possible to do it clearly. Article 4 clearly stated something like that. It was possible to do it for TDM, but it didn't happen for some reason. Can we go to the next slide, please? So, and the purgatory that I basically showed you is that it's a purgatory where we are basically building a system where ideas, actually facts and data, they are protected and they receive a protection which is indirect, connected to the container where they are. And this risk for us to build a specific type of framework and let's say also social value and system of morals and so, and the fact that I don't know if we really share, I don't know if we really believe in this. Can we ask the second slide, please? The last slide. And also, just a very basic consequence of this. It's not easy, probably, to undertake TDM in the European Union, right? So the best solution would be to buy a trained model, to chase a trained model from another jurisdiction, where maybe the training doesn't really take place according to certain standard and basically where the legislation is more chilled. So there is the risk of importing a system, or AI system, which works in a specific way. Here I just got the classic example of a loan system where basically discriminates certain type of users because the data and the information where this system has been trained was not the best, okay? And this means consumer protection. This means also in terms of those non-discrimination law. And to some extent, which is something that when I was preparing this presentation, I was thinking, it's like, to what extent GDPR is involved in this? Because we know when GDPR, the extraterritorial scope, but here we are talking about not processing European data. It's basically an AI system, an AI model processing data which were not European. So I don't know what is actually the extension of GDPR. I should some due diligence, but it's not very clear to me. And this next slide, please. And basically, what's the last point that I would like to present to you is like, we need to start looking at things in a bigger picture. Copyright is not just there in vacuum. It's there because it's a protagonist of what we offer to our European population, which means that regulatory competition is important because if we offer specific ground where specific uses and technology can develop, well, we can have, for sure, we can have certain benefits in terms of Europe. For instance, we know that, I like this expression that the United States won the internet, but the United States won the internet. And this was because if you think about all the biggest company in relation to the internet and giant tech platform, they are US-based. And this was probably due not because of the infrastructure of the technology, because South Korea and Japan, they were way stronger than this in terms of pure infrastructure, but it was because the legal framework was perfect for specific technology. What we now call platform, long time ago, were not considered a platform like in the modern way. But the Communication Decency Act, which only 10 years later we can find something in the e-commerce directive, basically made possible the internet to thrive in the United States, and that's why what we're experiencing right now. So there is the risk that this way of addressing text and data mining can be another mistake, or a mistake, something that maybe could have done in a different way. And so the irony is that I don't know to what extent the European Union wants to build a European digital sovereignty, because it seems that we really want to put obstacles in this path for us. And thanks so much, and I think I can conclude right now. Sorry, can I ask you? I'm very proud about the slides, so thanks so much.
Thank you so much, Salvatore. I'll give the time to switch to the very last presentation before the closing remarks, to thank you particularly for also giving us a very concrete touch on what text and data mining is. I mean, at a certain point, especially at the middle of this morning, it's good that we still know what we are talking about. So those steps, even for us legal experts, are always very useful to be reminded of. And when you were presenting them, and I'm saying this also beyond the European context, I still think we have two elephants in the room. One is more concretely the fact that we are processing something, and the fact that copyright law hasn't really got clarity on what using, processing, adapting, molding, doing really means. That's a problem that we need to address at a certain point. And a second, but I just want to stimulate the discussion because students are in the room and we studied so much about it. There is a second elephant in the room that is the three-step test, and no one is mentioning it. And maybe it's also the right moment to look at it. I have it on my whiteboard in the office. I just replicate it every word and say, how could I improve that if I could at any point in time? But that's for later. We have the very final discussion. I beg your strength and patience to hold up with us, because it's an important person I'm introducing to you today. Amanda Costa-Novaes is PhD student in Nova School of Law, researcher at our center, Nova IPSI, recipient of the Consumer Empowerment Project scholarship. So her PhD path that started at Nova School of Law, and then who knows where it's going to bring her, definitely is a good example of supporting academic research between disciplines, because we are looking at copyright law not only in a vacuum, as Salvatore was pointing out, but also really down on the needs of doing research that has an impact. So without further ado, Amanda, thanks again for all the work you put together and for accepting our invitation to put yourself outside of comfort zone, studying a legal system that you work with but you're not trained in, and presenting to us as very last point the text and data mining, or the copyright and AI debate in the United States.
Thank you, Professor Giulia. Good morning, everyone. Thank you all for being here. It's an honor to be here today with such amazing scholars, and especially with the sponsors of my PhD scholarship as well. So I think this is a very nice event for us. And well, I'm going to start without delays because I know lunch is getting close to. And I'm going to talk about using copyrighted material to train AI in the US. So is it a fair use in the US understanding or not? Let me see if the pointer works. No. So Aline, please, if you can change the slides, yeah. So if you have been sleeping until now, we are talking about AI that needs copyrighted content to be trained and to give an output that is original, that is new, that we are not going to talk about today because we are focusing on the input. So what goes in this metaphorical black box. And in the US, to use this content without having to licensing or ask for authorization for each and other work that you use, it these use need to be considered fair. So you have the fair use clause in the US system, in the copyright code. And what does this clause say? So it basically has some, not requirements, but elements that the judge needs to assess in order to determine if a specific use is fair or not. And this clause and these elements are basically if the use is commercial or not, and you see the first point. The second one is whether the copyrighted work is published and available, so it's more of a privacy concern. The third is whether the use is substantial, so whether in the original output, the original work and the second output, they are substantially similar or not, and whether the use affects the potential market value of the work. So we are looking at the market, at the consumer. So if the second work affects this potential original value, market value. But I know this is all a lot of things. Let's look at some case law that analyzed already this aspect so you can have a grasp of what they understand by that. And basically, you have the Google Books case, which is one of the most famous ones. And Google Books is a platform that actually Google went to a lot of libraries and scanned a lot of books, and they created Google Books. And Google Books allows you not to read the whole book that they scan, but allows you to have a little snippets when you research a certain word. For example, here I researched law, and they show me where the word law is in the book. So you can see little snippets of it. And what did the court decide in this case? Well, they decided that the service augments public knowledge, so they basically decided this is a very good tool that we are creating right now. We have more public knowledge, and you don't have a substitute of books, because if a person wants to read the whole book, the person will still have to go to a library, will have to buy the book. So they decided that although the use is commercial, because we are talking about Google, and Google is getting a lot of money in the end with all these tools, and they decided that we have no privacy concerns, let's keep the two. But the three, they said that the use is not substantial because you are not giving access to the whole original work, and also that you don't affect the potential market value of the work. So what did they say in the end is that this use is transformative. We have a new tool with a new meaning or a new purpose that is not competing directly with the first one. This was the Google Books case. And I'm going to bring you the second and last case that was one of the most recent ones about the fair use exception, that is the Goldsmith case. And here you can see Prince in the picture, and in my right side, you can see the photography of Prince, and in the left side, you see a print that Vanity Fair, the magazine, put in the magazine. And they claim that this was not the original work, this was a fair use of the photography. And the photographer, Goldsmith, went to sue them. And in this case, the court decided differently from the Google Books case. That said, that in this case, they say that the new work retains the essential elements of the first work. And they have the same overarching purpose. So what they are saying is that basically, instead of hiring the photographer, instead of licensing the picture that he took, you are creating a little bit of a different picture in order to put in your magazine, and you are stealing the same potential market value of the original photography. And here they said, well, it is not a transformative use. It is commercial, it is a substantial use, and you have an effect on the potential market value of the original work. So I wanted to bring you these two decisions because they are very relevant to assess when we are training AI. So let's all, no court decided already on AI input in the US. There are a lot of cases pending. I didn't bring you all of them because it would be a lot for my 10 minutes. And I want to do really with you all, step by step, the fair use assessment of AI training. And let's see, the first one is that we are talking about commercial use, right? Salvatore was talking about OpenAI right now, even though it's not for gaining money, so it's not lucrative. But when we are talking about OpenAI, Microsoft, Google, these companies developing AI, and putting out there for us, we can see the commercial purposes of these tools and these enterprises. So the use is commercial, right? We are not talking about academic research because in this case could be a different answer at all. We are talking about commercial use, but this is not impeditive, right? As we saw in the Google Books case, you can have a commercial use. The second point is also not a problem because they are using works that are available to the public, so we have no privacy concerns. What we are really talking about here is about the third and the fourth point. So whether the use is substantial and whether it affects or not the potential market value of the work. And this is very interesting in the US because you can have different answers. First of all, when we look at an AI use, for example, generative AI of images, I'm putting here some examples, but the main purpose of it is to create new pictures, new images that didn't exist before. So original outputs, as I mentioned in the beginning. However, sometimes this happens, and this is in the lawsuit of Getty Images right now in the US, and this is a problem of memorization. So sometimes the system memorizes something, the input that it was given, and gives you a very similar output from this input, right? And this can happen also with other types of generative AI. We have here an example of ChatGPT and New York Times. This is also in the New York Times lawsuit in the US. And everything you see in red is basically exactly the same from the inputs of the New York Times and from the outputs of ChatGPT. And what are the companies saying? That this is a rare bug. So memorization, regurgitation, as they are claiming. And here I think it's funny how sometimes we see AIs as humans that can memorize something or vomit something. But they are saying this is a rare bug, this is not supposed to happen, this doesn't happens in the majority of cases. And that actually, especially in this case of the New York Times, they are also claiming that the New York Times manipulated the machine to give this result that is equal to the input. So they are saying that also this manipulation of the machine is a violation of the terms of use of the platform. So you would be using a platform in a way that it shouldn't be used. And whether this use is substantial or not is something that the courts will decide already if they are going with the majority of the cases, if they really are going to consider this problem of memorization and regurgitation as something that is relevant for copyright purpose or not. However, this is pretty much the discussion right now in the US. And the fourth aspect, for me, is one of the most interesting ones, is that the effect on the potential market value of the work. Because here, right now, we can have different answers depending on the type of AI that we are talking about. Because AI is a technology that has various uses. We can have, for example, facial recognition systems that use artificial intelligence in order to determine if who is the person there, right? And recognize a face. In order to develop this system, you have to train the AI with a lot of pictures and images of faces of people and portraits, right? But what we are creating here is a very different systems than the photographies itself. So it's similar to the Google Books. We are feeding the system with a lot of photographies. We are using copyrighted photos to train the systems, but we are creating a new product with a new meaning and a new purpose that is recognizing the faces of people. We are not affecting the market value of photographers by creating these systems. We are creating a new machine that does a new thing, right? So here we can see that we don't have so much of a potential effect on the market value of the original works because we have a new machine, a new tool. When we are talking about generative AI, things get more blurred in these cases. For example, when we think about ChatGPT, are we really affect the potential market value on the works it was trained on, of which works, of books, of newspapers, of magazines, of blogs, basically? I personally don't think so. I personally think that we are creating a new products as well right now, that when you talk about, it answers you, so it is really a chat. and has a new purpose as well, right? But this is also something that the courts will have to decide, whether there you have a potential effect on the market value of the works it was trained on or not. And when we talk about generative AI of images, this gets even more complicated, because right now we are creating images that can be used for magazines, for events, for basically any purpose. So if the court looks too much in the potential market value of the work, of the photographers, for example, of the designers, it may have different answers. So, for example, you may have a fragmented approach in the US based on the use of the AI system that we are having, because some uses may be considered fair and transformative and some not. So this can also generate a lot of problems, because instead of having a exception like the TDM exception that you apply regardless, you may have different answers for different uses of AI. And this can be problematic, but as well, the courts will have to decide whether they are going to have a unitary approach or whether they are going to do this fragmentation. And basically, I just want to end asking what is at stake right now, because a lot of discussions talk about AI progress and creative industries as a battle. So some people are claiming, what are AI copyright incentivizing? Are copyright incentivizing AI creations or human creations? Because the key word of copyright, especially in the US, is to incentivize. And what are we trying to incentivize? I personally don't believe so, because I do think that even though when we are using AI, and I'm going to talk about generative AI of images, that is the most problematic case, when we are using AI, you have a human behind it, and you are using this machine to create art still for human enjoyment. So we are not talking about AI art. The AI is not doing for itself and for its own enjoyment. We are doing this still for humans. So when we think about the public domain that Professor Giulia started with, we really can have these machines to have more outputs in the public domain. So if AI is incentivizing art in all its forms, then I do think that AI is included in that. But we still have a lot of questions and no answers until that time. Thank you so much.
Thank you so much, Amanda. This concluded the speaker's contribution that we wanted to share with you. I'm left with a feeling of probably we managed to close a circle. I'm not sure we closed it. We enriched the discussion by really high-profile studies and contributions. Now, the last question that separates us from lunch, and also a very important music performance that I invite everyone to stay and enjoy with us later. The very final pending question is whether Philipp Homar can help us making sense of this. So I'm introducing to you once again a dear friend and an esteemed scholar in the area. Philipp is full professor both at the Johannes Kepler University in Linz and at the Vienna University of Economics and Business. He comes to Lisbon today to share this discussion table with us, with a focus on intellectual property law, because that's his areas of expertise. But I really, when I was thinking of the order of contributions, I really like to introduce you, Philipp, as one of the scholars that most closely look at intellectual property, also in its intertwining with competition law. Because we started in a provocative way, and by me calling your attention to let's open our mind and bring everything that is important to us in the discussion. For me, it was the question of public domain, where is it? We went through copyright and copyright intertwined with data regulation and information technologies, but I think we cannot have Philipp as an IP and competition law expert, reminding us that this is also a market dimension that Amanda hinted at. they probably could be solved also outside copyright law at a certain point. So if we fine-tune legal disciplines, I think we are looking at the problem and potential solution in a more refined way. So Philipp, thank you so much. We give you the last minutes of this morning just to help us wrapping our head around the topic.
Okay.
And thanks for accepting.
So thank you for the invitation. I will do my best. I don't think I will be able to fully fulfill the task of helping you and also getting the different views together. I think the background of the invitation was that I should share some ideas I had together with a colleague who is a public lawyer on the question whether actually there might also be a different way in order to create freedoms for follow-on innovation. It was an idea where we were exploring the concept of regulatory sandboxes, whether this might also be an option in the IP area. We discussed this last year at the University of Tokyo, but before I come to that, maybe I shared two thoughts also on the presentations that we had in the panel so far. I think we at some point heard the argument of distinguishing between consumptive and non-consumptive uses in the context of machine learning, in the context of AI training. And there is also in literature some views that say, well, non-consumptive uses, so where you're only using copyright-protected works in machine processes, so where no human beings are really enjoying the works, they should maybe not be subject to copyright at all. They should maybe not be subject to the reproduction right at the first place. And I think this is actually not the right approach, at least according to our current system, because I think that this would not be in line to what we know also from other processes where no machines are involved. For example, if I want to use a film only to get information out of it, I'm not really interested in the film expression. I only want to use the information. I'm a filmmaker. I want to learn how other famous filmmakers are making their films in order to make my own films. Or if I want to read your paper, I'm not interested in how you express yourself on a literary basis, so how you express things. I only want the information out of it. I download the film, I download the paper, and I only want to retrieve the information. I think it's clear this is subject to copyright law, this is subject to the reproduction right, and whether this is admissible or not is dealt with on a subsequent level. It's maybe a fair use scenario, it's maybe a fair dealing scenario, or in our European understanding, it may be covered by an exception. Private copying exception, research exceptions, and I think the same actually should then apply if we now do this with machine means. If I do not read your paper in order to get the information out of it, but if I use an AI system that is just summarizing it, so I don't think it would be convincing to say, well, now this is not subject to copyright at all in the first place. It's not subject to the reproduction right, it's completely exempted in the first place. I think it is actually comparable to other scenarios where I as a human being download it, so it is a reproduction, but whether it's admissible or not is then dealt with on a subsequent level, fair use, fair dealing, or exceptions as we are doing it right now. So I think in terms of comparability, it is the right thing to address it on this level. Of course, whether the TDM exception is broad enough or should be different, it's up to discussion. But I think at this stage, the question is to be addressed. Otherwise, we would have some contradictions, and I think it would not be convincing. So this is the first thought. The second thought is, as we don't have someone from Germany here on the panel, I'm also not from Germany, I'm from Austria. In Austria, we don't have cases at the moment regarding the text and data mining exception, but we very recently had a case in Germany from the Court of First Instance in Hamburg, in the Lion case. So it's, of course, first instance decision. It's was not something that was decided by the Supreme Court, but nevertheless, the case is interesting, although it was not about using a work for AI training as such, but rather it was about a subsequent, a previous use. So it was about using pictures that were available on the internet for creating a training data set. So not for training an AI system, but for creating a training data set that's then at the later stage could be used for AI training. And nevertheless, the decision I think is interesting because it indicates that the use that was conducted there is covered by the text and data mining exception, the research text and data mining exception, so Article 3 of the directive. Of course, it was not about AI training as such, it was about this earlier use, but nevertheless, it points in that direction, and it also draws this conclusion with the AI Act that we now have a provision in the AI Act, and therefore I think it leads into the direction that also AI training, although again it was not about AI training, may be covered as text and data mining. And interestingly, it also mentioned the 3 steps test. And the court then decided it passes the 3 steps test. But again, it was not about AI training as such, but was on this earlier use. But also here, it of course sheds some light in what the 3 steps test may be requiring. And it also, and I think this is quite interesting, shows a broad understanding of what research is. So the text and data mining research exception was applied here because there was an opt-out, there was a machine-readable reservation, but they did not have to obey this machine-readable reservation because they put it under the research text and data mining exception, which is, I think, quite a broad construction as the court did it. But it nevertheless went that way. So this was, I think, the first prominent decision that we are having from Germany. Of course, this may be overwritten by the subsequent instances, but nevertheless, the first court of first instance decided that way. And so I finally come to this research that I conducted with a colleague from public law. And the background was, well, we now followed the approach of creating freedom for AI training, so for new innovations, by providing an exception. The text and data mining exception, as we have it in the European framework. And we then thought, well, is it actually the only way of how IP law can provide freedom for follow-on innovations by providing exceptions, or may there also be a different way of how we could create freedoms for follow-on innovations? And then we took a look at the concept of regulatory sandboxes that we don't know in the IP law area so far, but rather from areas what we call public law, fintech regulation. So where is it now working? Maybe we can go to the next slide. Thanks. You can skip the slide, actually, I already mentioned that. Let me go to the next one. Yeah. So areas in public law where we have an authority that then creates some freedom for some innovators, selects innovators that are being admitted into the sandbox model, where then they have some privileges compared to other companies, other innovators that are not in the sandbox itself. This may be some guidance. There are various forms of these sandboxes, but this also may mean that some innovators that are in the sandbox that were selected by the authority into the sandbox, they are enjoying legal benefits. They don't need a market authorization. They may also enjoy some relief of legal requirements, some prohibitions that are not applying to them. And the question was, well, could you actually also do this in the area of IP law? So now in the private law area, that an authority may admit some innovators into a sandbox, and this then means, well, they have now freedoms, and they don't need authorization of copyright holders, of patent holders whatsoever, because they now have this privilege of being granted into the sandbox by a public authority, and therefore they don't need authorization, whereas all the other companies that were not being introduced into the sandbox still require the authorization of copyright holders, of patent holders. So this was the question that we had, whether this would be actually a permissible concept also in the area of IP law. And of course, there are some basic distinctions to be made, because if you compare these two systems in IP law, we're creating exceptions. So we now have the text and data mining exception for research, or the Article 4 exception for also other commercial activities. And this, of course, works totally different than the sandbox concept. Because if you have an exception, you have a legal tool that allows text and data mining for research or for other commercial activities, which means that all innovators, all companies that fulfill those legal requirements, they do in text and data mining as it is defined, they carry out research purposes, they are benefiting from the exception if they fulfill those legal requirements. And whereas in such a sandbox scenario, you would not have this catch-all approach where everybody that does text and data mining for research purposes is actually now benefiting from this exception, but rather you would have a more selective approach. There is a public authority that now selects some innovators which are being deemed as useful, as providing something, some innovation that we as society want, and only they benefit from an exception, from then this relief that they get. They don't need an authorization, where all the others that were not selected are actually still in the general framework, which means they are not having this benefit of this copyright or patent relief. And of course, there are then differences because such a sandbox model would mean a more steering approach. You're guiding, you're selecting innovations that we as society deem useful, whereas at the moment, under the general exception scenario in copyright law, we are not making this guidance. We are just creating these exceptions that are benefiting all of companies, all of innovators that make text and data mining for research exceptions or for other commercial exceptions. And this is not this distincting between innovations, whether they might be useful for us as society or whether they might lead to something that we actually do not want to have. For example, if I now make research, if I carry out research for pharmaceutical endeavors or for other useful scenarios, I want to tackle climate change, I'm benefiting from the exception just the same way as some other company that is carrying out text and data mining activities for creating, I don't know, a social scoring algorithm, for creating some efficient weapons, or maybe for other activities that we actually as society do not really want to have. But all of them are benefiting from the text and data mining exception if it is research, but the purpose of the research as such is not defined. So everybody's benefiting here in this scenario, whereas in a different scenario, if you had such a sandbox model, there would actually be someone who acts as a gatekeeper into this benefiting system, and then you would have a more selective approach. So our conclusion here on this aspect is we don't have this right now. It would be a completely new approach in the area of IP law. But at the same time, we think that it would be admissible to have such a system. Why? I think there are basically two concerns that could be put against such a system. First is more coming from the public law side, because you now have a different treatment. You're treating companies, you're treating innovators differently. There are some who are selected into the sandbox where others are not. But I think this is not an unsolvable problem, because if you have sandbox model work in other areas, in fintech regulations, where also an authority is selecting some innovations that should benefit and others are not, so this can be achieved apparently, that it is being put in line with the principle of equal treatment. If you have a sufficient legal basis, I think from a public law perspective, this is something which might also work and which is not creating some obstacles that cannot be overcome. And the other question is this actually allowed from an IP law perspective as such? That an authority now creates some environment, some benefits for some companies because they don't need authorization from copyright holders, from patent holders. And I think also this might work as long as, of course, it is in line with the international and European framework for exceptions that we are having. If we now have the exception for text and data mining, I have to tolerate as a copyright holder that everybody who is doing text and data mining uses my work. I cannot do anything against this. And in a scenario where you have an authority that says, well, some companies are now being introduced in the sandbox, and those that are inside, they don't need authorization from the right holders. I, of course, as a copyright holder, had the situation, this is less intrusive to my interests because I don't have to tolerate all uses from all companies, from all innovators, but I only have to tolerate some uses from a selective group of companies that are being introduced into the sandbox. So I think as long as these benefits that are created by those sandboxes are in line with the international and European framework for exceptions, this is actually also in line with these requirements. So our conclusion is it would be possible to also follow such a scenario in the IP area. Of course, a different question is if we should also do this. So we are not arguing that this is a model which should be done for future freedoms that we are creating in IP law, whether this might be a better solution for the AI training. But we argue it would be possible. It could be brought in line also with legal requirements. But if this is something that actually should be done, of course, it also has problems. You then have an authority that is selecting what is useful, what is a useful innovation, and what is not such a useful innovation. There is also the argument that this decision should be being made by the market itself, that the market decides what is useful or not. But again, we're not arguing that it is a concept we should follow. We just say it is a concept which might be an option also for future scenarios when we want to create freedom in the area of IP law for law and innovation. So that's it from my side, and I look forward to the discussion. Thank you.
Thank you so much, Philipp. I feel good about this morning. I think a lot of thinking that we could not expect in terms of sharing our current studies and our more or less partial findings in this topic made a very good ensemble of information. And Philipp, I think I personally, having talked about this in previous occasions, I find this idea of bringing a regulatory sandbox down on earth and inside IP, I find it extremely inspiring, but I find it particularly useful in a conference like this one, because it really helps us, and Rossana in our presentation was referring to 2009, the Obama election, and I jotted down in my notes, an IP sandbox could feel down to on earth, so explain to the public as a yes they can, but only they can, right?
Yeah.
And that's something we never juggled with. We never talked about there is no copyright infringement in the sense that we want to promote someone. We always promoted some sector in society or some professional figures by giving legal protection, not by giving them the freedom to be free or not affected by the risk of a copyright infringement. And I find it counterintuitive, thought-provoking, but extremely useful. So personally, but we will see during our lunch if more people agree with me and come to you, I would encourage you to continue and dive into the question, should we go there? Because your research is we could, but I see a lot of reasons why probably we should pilot it. Now, as it is usual in academic etiquette, obviously we don't just send you all for lunch without opening the debate. The idea of this conference was an intense morning of information flowing, and then during the lunch break, the discussion should continue. So we do invite you, first and foremost, to reach out and to ask questions and engage in conversation during the lunch break we have downstairs. That's what we thought it could create best knowledge in the room. But we are here at disposal to collect some questions from the audience. So online, we do have the chat, and we have also some people who can collect. If there are too many, I apologize in advance. I will collect only a few, but again, we will move downstairs and continue the discussion. So I'll give the floor to 1 and 2, and